I would just
Okay,
like to thank you, Claire, and the Library of Michigan for presenting this webinar. Timing is everything. It's right around the corner before it'll be effective for the small libraries. So I just want to thank everybody that has joined us. I think we need to make sure that we're all on the same page of what needs to be done by October 1st. So
absolutely.
that's what we're going to try to accomplish this morning. And so let's just get into this and start working through it. With respect to questions, Claire, I'm not sure how we want to handle the questions, but maybe you can watch the
Yep,
I don't know if you're using the chat box or
yep,
the Q&As or both. I always find it impossible to do both, but
yeah.
you
I
can
think,
monitor that, and
yep,
then I'll go through, and if you feel it appropriate to interrupt, feel free to, and we can
okay,
field the questions as we go.
okay. And we should have some time at the end as well to address
All right.
some. But yes, please, everyone, just throw your questions in the chat and we will keep track of them and address them as we can.
Okay, perfect. And with that said, let's just start. For the small libraries, small employers by the terminology of the statute, the effective date is October 1st, which is right around the corner. It's in a few weeks. There's a history, and I don't want to spend a lot of time on the history, but I think it's important, especially for the small libraries that may not have been paying attention when the prior law came into being. I think it's important that everybody knows where this all came from. So I'd like to spend some time just talking about that. The Earned Sick Time Act, the acronym ESTA, actually started in 2018 as a ballot initiative. So it's been around for quite some time. And the ballot initiative got enough signatures to become the law. So what the Michigan legislature did at that time is they adopted it. And the Constitution says they can adopt it, and then it doesn't get voted on. So that just becomes the law. So this was, in fact, the law in 2018. But what then happened is after it was adopted, it was amended. Some called it a bait and switch. The courts called it a adopt and amend strategy, and that was legally challenged. So when it was adopted at that time, it was renamed to the Paid Medical Leave Act. So if anybody sees or Googles or looks at this or whatnot, and they see the Paid Medical Leave Act, and then they see the Earned Sick Time Act, they are the exact same law, except the PMLA was ESTA as revised in 2018. So if you see that those acronyms or whatnot, it's the same law, it's just that different versions of the same law. And many of the people with us today probably could have just tuned out, and I think probably did tune out because the PMLA only covered employers with 50 or more employees. So it basically tied in more to the FMLA. It didn't cover you, so you didn't have to pay any attention to it. Well, then you fast forward almost 3 years of litigation over whether that was appropriate. And that a couple of courts said, yes, it's okay. A couple of courts said, no, it's not okay. So where does this go? It goes to the Supreme Court. And the Supreme Court ruled that the adopt and amend strategy that was used was unconstitutional. So almost 3 years after this was supposed to become law, we had to start over. And so the PMLA was thrown out. So anything you now see with PMLA is no longer effective. It's not the law. What is effective is the original ESTA, but with one critical difference is the effective date because the court got, by the time they got it, what the effective date had already passed. So now what do? You have to get up to speed. You have to figure out everybody has to know what they're doing. So that's where the February 21st, 2025 date for most employers came into being. But then the statute also says, but February 21st for small employers, we're going to give small employers more time. So they put in, and the Supreme Court did this, they put in the October 1st date just for the small employers. So that's really where we've been, where we're at. So you're gonna, if you have looked at it, if you've been following it, if you, after this webinar, you jump on Google and look at it, you're gonna see a whole lot of terminology discussion, what was done. All you really need to know is what the Earned Sick Time Act for small employers effective October 1st, 2025 is. That's what we're talking about today. So to cut through that, the question becomes, what is a small employer? And a small employer, for our purposes, is any library that employs 10 or fewer employees. And just to confuse everybody, that was a change from the ballot initiative, which would have been fewer than 10 employees. So they changed at the last second from 10 or fewer to or fewer than 10 to 10 or fewer. So I'm not sure why they did that, but there's been some tweaking and nuances that may or may not make sense, but it's important we know exactly who is covered and why. So the standard now is 10 or fewer employees, and that includes all employees, everybody. It includes your regular full-time employees, it includes your regular part-time employees, it includes your temporary employees. If you have any employees that come through a temporary help agency, it's going to include them as all. So it's all inclusive. And so you look at all of the employees on the payroll, and if there's 10 or fewer, then you're a small employer. But you got to take a sort of a snapshot in time, and is this now if you hire an 11th, are you a larger employer, and then you have somebody leave, now you're 10, so you're a small employer again? The answer is no, that's not how it works. Once the library employs its 11th employee for more than 20 weeks in the current or prior year, you can no longer be a small library. So it's a formula. You have to look at your payroll for the current year and the prior year. And in those 2 years, if you have had an 11th employee or more in 20 or more weeks, you will not be considered a small employer for at least 2 years because it's a 2-year rolling period. So right now, for your purposes, and I assume since people are joining the seminar, or webinar, you consider yourself to be a small employer, but if you want to test that, if you're close to the line, you need to check to see if you have in this year or last year an 11th employee at any time, and if so, did that person work for more than 20 weeks? So that's the test they use. Now, with that, there's also a notice posting requirement. And for most libraries, ESTA took effect February 21st. For the small libraries, it takes effect October 1st. But the Supreme Court decision also picked up a notice posting requirement out of the statute and threw us another curveball because they said on March 23rd, by March 23rd of 2025, the all employers must have a notice posted. And so the notice posting tells employees what ESTA is, what their rights are. It's a general, not a detailed notice, and we'll talk a little more later in this webinar about the notice requirements. But there's a posting requirement. So even if you're sitting here and you said, well, ESTA doesn't apply until October 1st, so we've put it out of sight, out of mind until now, and now we're going to look at it. If you have not posted that notice, you need to do so immediately because that was supposed to be up quite some time ago. So you can find that notice on the Wage and Hour Division website. You can just print it out, put it on your wall, and you're compliant. If you haven't done that, I would recommend you do that at the top of your to-do list after this webinar. Because if you get audited or if you get a call from the Wage and Hour Division, I think that's the first question they're going to ask you is, are you in compliance? Well, we're getting into compliance. Have you posted your notice? And if your answer is yes, then you're going to get a check in the good employer box. So I would recommend you do that.
Hey, Mike,
Yep.
there are two questions regarding employee. So one is, does the employee number include board members? And what about substitute librarians or contract employees?
The board members are not employees generally. They can be. Generally, they are not employees, so they would not be covered. With respect to contract employees, the answer is yes. If they're a
Right.
contract employee, they're an employee, they would get a W-2, so they would be considered.
Okay. And substitute librarians as well, like people who are called in only on an as needed basis.
Yes. Yep, they would be covered. And there is an issue, we'll talk a little bit. There's another slide where we can get into this in a little more detail.
Okay.
But it's all inclusive, it's all employees. And when you see on call, sometimes you look at there's a couple of exceptions that yeah, I will talk about in a little more detail, but the exceptions are very narrow. And if you have an on-call person where there's an ability, they're not going to be a volunteer because if they might be voluntary if they call in. They don't have to call in, but if they do call in, they expect to be paid, and they are paid. And that under the Fair Labor Standards Act makes them an employee, so they're covered under ESTA. You could have a volunteer that is not expecting any pay, doesn't get paid, maybe a stipend or whatnot. So you have those nuances, but generally, if you have a contract employee that is performing services for the library and expects to, and does get paid, or an on-call under those same conditions, they would be counted as an employee under ESTA.
Thank you.
All right. And I think what that does then is it gets us to the accrual and the usage. This is another area that you have to pay a little close attention to the terminology. The terminology is on accrual, and we'll also talk about an alternative method, but the accrual under ESTA, employees are entitled to accrue at least 1 hour of sick time for every 30 hours worked. That's a minimum. You can accrue, you could give, 1 hour for 21 hours worked or anything more generous, but that's a minimum. The accrual, and I've seen a lot of discussion on this, and I've received a lot of calls on this, is you can cap the accrual, right? And the answer to that is no. There is no capping of accrual. The accrual is you get 1 hour of sick time for every 30 hours worked. And if you work enough hours during the year that would go beyond the usage cap, you're still accruing more. You just can't use it. So it's a little bit of a nuance, but you do not cap the amount of accrual. You put it in the bank. Then how do you control it? You control it because under ESTA, The small libraries can limit use to 40 hours in each year. So you might have more than 40 hours accrued. And then we'll talk about rollover, but you could have, 40 or more hours in the bank. But in any given year, the library can limit the use of sick time to 40 hours. So don't, at least in your records and in your discussions, mix up the accrual and the usage when you use the word cap, because they accrue for every hour worked, but that doesn't mean they can use everything they accrue. Now, with respect to carryover, if employees get sick time through the accrual, carryover is required. And for the small libraries, the accrual is you accrue the time and let's assume you accrue 50 hours. Then at the end of the year, you haven't used any. What the ESTA says is that you must be allowed to carry over 40 of those hours. The other 10 would be lost. The regular libraries, the larger libraries or larger employers, it would be 72. But for the small libraries, any time in the sick bank, up to 40 that has not been used must be carried over into the following year. And then you gotta, and so it's kind of rolling forward. So you have in next year, in 2026, you have 40 hours, you carry it over. The following year, you accrue another 40 hours. Now you have 80 hours in the bank. And if the person never takes sick leave at all, then that could, get into the hundreds. It doesn't matter how many are in that bank. Again, you got to carry over every year up to 40 unused in that year. And then in any given benefit year, you have can limit the use. So it's kind of a mathematical issue, but how you do it is important for compliance. So you keep track of how much time is accrued, how much time is in their bank, but then you control it on the usage side. Now, if you don't like the idea of carryover, there is an alternative. And the alternative is front loading. So front loading means at the beginning of whatever you use for the benefit year, and let me just back up. A benefit year is what you use, a 12-month period you use for purposes of, in this case, sick time. So it could be the calendar year, it could be the most common in the calendar year and the fiscal year. If you use the calendar year, you use the fiscal year, or you could use any other 12-month period. But so each individual library can set their benefit year. In the first year, so let's assume for the moment that you have the calendar year. You use the calendar year, and October 1st is the effective date. So the time for accrual for the first year from October 1st to December 31st can be prorated. The following year, it would be the entire year, unless you have a new employee. And if you have a new employee, you can prorate from the date of hire through the end of the year. So that's, you can prorate it. Otherwise, you have to accrue 1 hour for every 30 hours worked. But if you front load, then you front load at the beginning of the benefit year, the full 40 hours. You just put 40 hours, and this is for full time, you just put 40 hours into the bank, and you don't have to worry about how much time is accrued. You don't have to track that. Um, the potential, well, I don't know if it's a downside, there's pros and cons to everything. In the front loading for the full-time employees, you don't have to accrue. When they use it, and it's out, you're done. The one thing with front loading, though, is front loading has to be made immediately available. Otherwise, there's normally a 120-day waiting period that you can require. So new employees have to wait 120 days to use it. If you front load, you cannot use that wait period. So you front load it, the employees can start using it immediately, but you don't have to accrue the time. Part-time employees on the front loading is a little trickier because part-time employees, you don't have to front load 40 hours. What you need to do is you need to tell the employee in writing how many hours they're expected to work during a year. And then based on that expectation of hours to be worked, you calculate what they would earn under the accrual. So 1 hour for every 30 hours expected to be worked would come out to whatever the math does. You front load that amount, and the employee knows how many hours they're expected to work. They know how many sick hours they were put that it has been put into their bank that they can use immediately. With part-time employees, though, you still need to track the hours worked because if they work more hours than expected, you expected them to work, say halftime, and they were really busy and they worked more hours than expected. Once they reach that amount, you're going to have to add additional sick time because they worked more hours than expected. So for part-time, it's a little trickier. So now let's just talk briefly about the sick time, and I'm talking about the sick, the time spent put into an employee's sick bank. And for a lot of libraries, um, especially for the part-time, you might not have any other benefits for paid time off. You might not have vacation, you might not have normal PTO, so you might just have a sick time bank. Um, other libraries have both sick time or vacation, or at least now we'll say, well, wait a minute, we've always had vacation, at least for full-time employees. Now we have sick time. Do we have to have two banks, a sick time bank under ESTA and a vacation bank? And the answer is no, you can combine them. There's nothing wrong with having just a single, or what the wage and hour division calls a one bucket policy. So all of the paid time off goes into a single bucket. It can be used for any and all purposes, including sick time under ESTA. The only thing, if you use that one bucket bank, then you got to make sure that the policies and the conditions for using that PTO time in that bank complies with ESTA. So you can't have stricter use requirements, notice requirements, or whatnot to use time out of a PTO bank if you combine it with sick time, but it is permitted to have one bank. So this will get us to the issue that we just touched on a little bit, and there are exceptions to the definition of employee. The unpaid interns are not employees. Unpaid interns are not expected to be paid. They're not considered employees under the Fair Labor Standards Act. They're not going to be employees under ESTA. Uh, uh, and Claire, I think this is the question that we're
Mhm.
following up on the question that you uh, read a little bit ago. So this is where the statute addresses that. One of the areas that has caused a lot of discussion, and I don't think Wage and Hour has completely gotten their arms around it yet either, is an individual that works under a policy that allows an employee to schedule their own hours. So the employee has no schedule on call. and the employee can call in if they want to, when they want to. They schedule their own hours because they don't ever have to call in. There was a lot of thought that that exception, which is a statutory exception, would cover on-call employees. Wage and Hour Division says, I don't think so. They said that is intended to be a very, very narrow exception, probably owner of the company that doesn't really count as an employee. They can come in whenever they want, but they can do whatever they want. They're the owner, so they can't get reprimanded. They don't get taken off a call list if they never call in or whatnot. But if there is a requirement or an expectation that people will call in at least periodically, and if they don't for a number of years, they get off the call list. That's going to be enough control to say this doesn't cover it. So I think that to use this exception, you have to have a written policy that says you can schedule your own hours. And no matter what you do, if you never ever come in, no matter what you do, you will never have anything taken against you. You will never be taken off the call list or whatnot. I don't think that's reality. I don't. That's why I don't think this exception is going to cover very many people. The other exception that I've had a lot of discussion on is volunteers. And volunteers, there's a little bit of confusion that I've seen come in because volunteers, there is a regulation. It's Fair Labor Standards Act regulation that got picked up by MTA, and there was some discussion on it says you can be a volunteer even if you're paid. And so even if you get paid, you can be a volunteer and you're not covered by ESTA. Well, you got to step back from that and say, wait a minute, what's going on here? A volunteer, there's volunteers that are paid, and there's volunteers that are unpaid. And there's volunteers that are through 501c3 organizations, and there's volunteers who are not. So there's a lot of nuances here. And I don't want to drill into all of these nuances. I know, Claire, you have done some work on the 501c3 issue. And so I think you actually have a white paper or whatever you call it on that point exactly, that people can find your analysis of it on the Library of Michigan website. But the big picture here is the regulation that is cited, both by MTA and everybody else that's picked up on it, is not an ESTA regulation. It's a Fair Labor Standards Act exemption. And the exemption says that if you are a volunteer, which is defined as somebody who, on their own, volunteers to perform services with no expectation of being paid, then they may be exempt as an employee. So they don't have any expectations of pay. They're not considered an employee under the Fair Labor Standards Act. They don't get a W-2. There's no obligation to pay them. They might get what I would call a stipend. The regulation just uses pay. It can be a small amount. That doesn't destroy the volunteer status. But if you have an on-call employee and they're on a list, they call in. If they call in with an expectation that for what they do, they're going to get paid, this exception's not going to fit. So that's where I see the difference, but there's a lot of nuances, and this is one of the areas that if you have somebody that is close to the line that you think maybe doesn't count as an employee, this is time to discuss it with your employment attorney because there's a lot of little nuances. But I would err on the side of assuming that the wage and hour is going to find the person an employee covered under ESTA.
So Mike, there's two things I wanted to ask. So if you have an employee who's an independent contractor and has, a 1099, they would not be counted as an employee, correct?
No, no. As long as they're truly an independent contractor.
Right.
And so you can be a independent contractor, meaning basically they're in business for themselves. And they as long as you meet the test for the state of Michigan, economic reality test, as an independent contractor, they would not be an employee.
Okay. Um, then the other question is, so if we have a question here on the chat that says, okay, they have a part-time IT person and a janitor, but each of those positions work on their own hours. There's no schedule. Like they pretty much work when, I'm guessing from what it says here, when they want to. So I'm guessing the janitor comes in on their own schedule, has a key, comes into the library, cleans on their own schedule. Um, but so I'm not sure if those would fall under that exemption.
I think that the closest exception that potentially could cover that is the second one.
Hmm.
They schedule their own working hours. But again, wage and hour has taken the
Yeah,
position that that is very, very narrow. And if, let's assume that you have the janitor that tells you, well, for the next 3 months, I'm not coming in at all. You can't do anything about it under this exception.
right, right,
So
right.
I think that's a problem.
Or if you say we want you to come in when the library's closed, we don't care when you come in, but it has to be when the library's closed. Well, then that also is not under
Right.
that criteria. Yeah.
Yeah, we don't care when you come in, but you got to come in. Under this
Yeah.
exception, that if they never come in, you really can't do much
Yeah.
about it.
Yeah.
At least that's the interpretation that I have seen wage and hour given.
Yeah.
That's how narrow it is. So no, I think that janitor would be covered.
Yeah. So Susan, I would double check with your attorney because you have a couple issues there, especially if you have 12 employees, that including those two people. So I would double check all of that before you set your policy.
Yeah, and some of this does really drill into the it gets you down a rabbit hole, I guess. So the devil may be in the detail.
Hmm. Hmm.
So I agree, but based just on the big picture, I think there's a chance that the janitor, at least the janitor, would be considered an employee, and if that person has been around for at least 20 work weeks as the 11th employee. Um, you might not be a small employer.
Right. Right. And the whole independent contractor thing, there's been a lot of discussion in like labor and circles that I've been reading about that those new standards, those new uh, what regulations or standards of what makes an independent contractor.
Yeah, that's been one of the pendulums for the last,
Exactly.
you know,
So,
they were trying, there was a bill in Michigan that would have basically brought in what is known as
mhm,
the ABC test.
mhm,
I don't think that's going to happen. That's the test out in California. That's not Michigan. I don't see that coming
mhm,
in. The economic reality test is what we're
mhm,
under. I think
mhm,
that's probably the standard.
mhm,
But the economic reality test, and it's somewhat detailed, but it is fact specific. But
mhm,
if you look at it, if even with this janitor, if you had them as an independent
mhm.
contractor, if they're dependent on the library for income, the economic reality test is probably going to make them an employee.
Right.
So there's
So if you have people you think are independent contractors, you want to make absolutely sure before you make your decision. So again, it might mean contacting your attorney.
right, because if you're wrong on that, not only do you have ESTA problems, but you might have misclassification issue.
Yeah. Okay, well, we just had another question pop up here.
Okay.
Is it strictly by employee? I'm thinking of an hourly employee that does two positions at different rates, clerk and housekeeper. Is that one or two employees for these purposes? So if
That's
you have
one employee.
one employee, okay.
No, but let me, yeah, there's nothing improper about having one employee paid two different rates for
Hmm.
two different types of work. The question on that is going to come in. They take sick time. What do they get paid? So that's
Correct.
where I think that issue comes in. And the answer to that is you probably, under those circumstances, would need to figure out what they're using a Fair Labor Standards Act test what their regular rate is. So you'd look for a period of time on what their wages were, their hours worked. You would get their regular rate of pay. And for sick time, you would pay them out at their regular rate of pay, which is a combined regular amount. So it's a formula that you take all the wages paid over a period of time divided by the hours worked, you get the regular rate. I think
Hmm.
that's probably what you're going to need to do for sick time. Again, this is going to be dependent on the circumstances.
Hmm.
But if they have two different jobs, I suppose if you could isolate it and say, well, they called in sick, when they were supposed to do this job, so we'll pay them that rate. If you can isolate it that closely, that might be appropriate. But it's probably safer. And there is a FAQ on Michigan's Wage and Hour website that has that exact question identified, and it talks
Hmm.
about what has to be paid, and where they basically come down is you want to use the regular rate.
Hmm.
So, but no, that would not be two employees.
Okay. Last one here. If I have a cleaner who owns his own company and comes in to clean 6 hours a week and he sends us a bill, is he a contract worker or just a company we pay to do a service?
I would view that as contract services.
So a contract worker?
You're contracting with a company to do the work.
Right.
You're not paying that
So,
individual.
okay.
And I think you got to I think in that situation, you're paying the company for
Right.
services performed by the company. You're not
Right.
paying the individual that did the
The
services
work.
an amount that shows up on the W-2, right?
Right. Yeah, that makes sense.
Yep.
Okay. Thank you.
Okay, time to move on.
Yes.
All right, then let's get to the probationary period. I mentioned this. This is one thing you give up if you have if you front load, but if you have employees earning or getting sick time through the accrual method from the time they're hired until 120 days after employment. They can, during that 120-day period, they accrue sick time, but they can't use it. And then after they complete the 120-day period, then they can start using it. So this is a situation where I've seen come in, um, and the idea is you don't want to bring in a new employee, have them, they haven't even worked a day. Day one they show up, they work. Day two they take off. Day three they take off. They're just not going to ever really accrue much in the way of sick time because every time they get any, they use it. And you say, no, you can wait to see if this is going to work out. You can wait 120 days and then allow the employee to start using it. Um, so that is the downside to front loading, I guess. Although there is a provision that if they use up more than they would have accrued under front loading, you can recoup it. But that's a little complicated issue, and collection is hard. So that's why some people say, no, I'm not going to give all of these employees the time right on day one. They're going to use it and then leave. If you want to avoid that, you can make them wait 120 days. The other place, though, that I've seen this probationary period get a lot of discussion is if you have seasonal employees. Because seasonal employees, if you have somebody come in just for a certain season and then they accrue a certain amount of time. This is usually people that don't work a lot, so they accrue some. They have some hours in there, but then they get laid off, terminated because the season ends. And there's no obligation under ESTA to pay out um, unused sick time, uh, when they leave employment. And then the next year they come back, they get rehired. That time is not going to be in their bank unless they're rehired within 2 months. If they're rehired within 2 months, then it has to be put back into their bank. But if the 2 month break of service, any time that was accrued is lost. So if you have employees that have to wait 120 days to take it, then the season ends. Even if they have accrued time, they're likely going to not be able to use it. So that's one area I've seen a lot of people taking a lot of looks at if you use seasonal employees. And then this next bullet point here, Claire, is what we were just talking about on the wage rate clarification. I talked about the regular rate and what goes into it. What does not go into the rate that you have to pay for sick time, you don't have to include overtime. You don't have to include holiday pay. You don't have to include bonuses, commissions, supplemental pay. The idea here is what you do use is the pay for hours worked. So anything outside of that calculation does not have to be included in the wage rate for sick time. But again, I think the best practice, if you pay an hourly rate, pay the hourly rate. If you pay two rates, use a blended regular rate. But if somebody says, well, I was paid for a holiday pay and that's not included, you don't have to. So now let's talk a little bit, and this is something that I think everybody's probably been working on or should be working on. The notice, I talked about the posting that has to be, there was supposed to already be up, but under the FAQs and the way the statute is written, there's a couple of different notice requirements. And the March 23rd date that we talked about, when the notice was posted, that is a written notice. It's not unlike the notices that you have for all the other laws. I mean, if you go into the employee's break room or whatever, you probably have notices that say this law provides this law provides that. That's what this notice basically is. And it talks about the employee rights under ESTA. And that's the notice that was supposed to be posted by March 23rd. And so if not, you can download it on the link I gave on a prior slide. And that is the notice posting requirement. But employers are also required to have policy or some sort of posting on anything that on their administration of ESTA. So if this notice posting is a generality, it's not going to say the details of how you're administering the sick policy. So you should have in your handbook, if you have a handbook, or if not, in a sick policy or a PTO policy, all of the requirements on what they're getting, how they can use it. If there's notice requirements from the employees, what's required there. And this is something that should go into a fairly detailed policy. If you don't have a requirement in a policy, you can't enforce it. The employee has to know what the requirements are. And Wage and Hour is going to want to know how you're enforcing this. So you may have a lot of requirements. You must call in if you're not coming in by a certain time. The statute says if it's foreseeable, you can require at least 7 days advance notice. If it's not foreseeable, you have to give as much notice as is practicable. But one of the amendments at the very end was, but if the employer has a policy on how they call in and when they call in and under what circumstances, that's going to be enforceable. So you have to make sure that employees know that that what they have to do. If they wake up, they realize they're not feeling well, they can't come in, who they have to call, the requirements. One thing you can't do, though, to take sick leave is you can't require the employee to find a replacement employee to cover for them. I've seen some policies in the past where to take PTO or to take time off here or whatnot, that's fine. You can work it out with other employees, but you need to work out the coverage. ESTA does not permit that, but it does allow a policy on what notices have to be given. Um, the documentation is something that it's kind of a big change in the employment world. In the up until ESTA, if employers had employees that were thought maybe taking sick time and weren't sick, or any other time they were taking time off, they were putting in for a leave, and there was a question as to whether they were really taking the leave for that reason. You could test it by requiring documentation. The ESTA didn't like that idea. They said that's really an interference with this employee's right to take sick time. So the way where they landed on this is they said you can, as the library, you can require documentation to substantiate the need for sick time, but only under a couple of conditions. One is it can't be for less than 3 consecutive days. So if you have somebody, a Monday here, Friday, and then the following Tuesday or whatever, and you're seeing something that looks excessive, you don't know what they're doing, but it's not 3 consecutive days, you can't ask for medical documentation. If it's 3 consecutive days, you can. And if you, as the library, probably the director, says, okay, you've been out, you need more than 3 days of sick time, you need to provide a doctor's note. That's the reason for the absences. The employee then has 15 days to provide it. But the 15 days is to allow the employee to go to the doctor, get the documentation, and give it to you. That may well come with an out-of-pocket cost of the employee. The employee may have to pay, depending on the insurance, they may have to pay a copay. There might be a charge by the doctor's office to fill out a form or whatever. The library has to pay that out-of-pocket expense if they require the documentation. So I think that's brand new. I don't know of any law that required that prior to ESTA. And then the next bullet point, the last one here, we already touched on this, but reinstatement of unused ESTA within 2 months of separation. Originally, this was 6 months. It was reduced to 2 months. So this is, the we talked about the carryover. You have to carry over. Then employees may, at the end, have quite a bit of time in the bank. There's no obligation when that employee leaves to pay out unused sick time. It doesn't matter if they quit, if they're terminated, if they retire, whatever. When they leave employment, whatever is in their sick time bank does not have to be paid out. It can, if you have a policy to do that. Some PTO policies do, but you don't have to under ESTA unless the employee, and it doesn't matter if it's a quit or a termination. Again, we talked seasonal, but if somebody quits, they look for start a job someplace else, they don't like it. They come back to you and they say, I made a mistake. Will you rehire me? You say, oh, sure, that, yeah, we'll rehire you, put you back on the payroll. If that's done within 2 months, any time that was in their bank has to be reinstated. So those are the basic requirements. Now, there's a couple of issues that we should talk about on what if you don't? I guess I'll put it that way. What if you don't? What if we make a mistake? What if we intentionally disregard it? What happens? Um, and there's a lot of this was a lot. There was a lot of discussion, a whole lot of discussion, and a whole lot of changes as these laws came through. Um, the the brightest line here is that there can be no adverse action taken against any employee who uses sick time under ESTA. But if there is misuse, and this was a change because originally it was kind of a bright line, you cannot take adverse action. There was a presumption that if you took an adverse action, termination, a suspension, whatever, after somebody took sick leave, then it was presumptively a violation of ESTA. That was modified and it said, wait a minute, if there's misuse or if there's a violation by the employee of the notice requirement, that doesn't mean that you cannot discipline for failing to follow your procedures. But if the reason why somebody was absent was said, and you say, nope, that's excessive absenteeism is going to result in discipline up to and including discharge under ESTA that is strictly prohibited. You cannot take any action against an employee for having taken sick leave under the statute. Another big change in when this became the law, the original ESTA, the ballot initiative, gave a private right of action, meaning that if there were mistakes made, and when I said a mistake or intentional, I said that intentionally because the fear was that inadvertent mistakes, when there was a right of private action, meaning filing in court, could result in class action litigation. So mistakes could result in a lawsuit, a class action lawsuit against all of the similarly situated libraries that interpret this in a certain way. And the in class action, frequently what do? Because it's too expensive to litigate, you settle. And so there was a lot of discussion over whether this should be in the courts to enforce or not. At the end of the day, they said no, there's no private right of action. So what's an employee do if they feel that there was a violation? They jump on the Michigan Wage and Hour website and it tells them exactly how to file a claim, but they have to file the claim with the Michigan Wage and Hour Division in order to get any uh, a claimed violation addressed. So, what that does, in my mind, it's important that you have the proper documentation. If Wage and Hour knocks on your door, then you can say, yes, we knew this law was coming. This is what we took in anticipation of it becoming effective. We are in compliance. Wage and Hour, if they think a mistake was made, I think they are going to work with you to correct it. Probably through your attorneys or whatnot. But I don't think they're going to come down and say, "Oops, you made a mistake. Here's your $1,000 fine." I think they're at least initially going to work with you. So it's good to have your documentation in place, what policies you have in place, whether you're front loading or accruing and everything we've been talking about. And then when the investigator comes in, you can say, yes, here's everything we have. They're going to work with you, and if there's a mistake, I think they're going to say, well, as long as you make this correction, come into compliance, we're good to go. If you don't, or if they think you're playing games, or if they think you're trying to work around compliance, it can get expensive. It can be $1,000 per adverse action. It can be 8 times the hourly wage rate for failing to provide sick leave that was owed, and it can be $100 for each notice posting violation. So again, back to the posting that was due in March. Get that up. You've been racking up $100 a day since then. So cut that off. Um, but as long as you do that, and everything I've seen from the wage and hour division is they want to work with employers. They want to make sure employers are doing this right. They're still learning a little bit, so they're not going to be real tough on areas that they're still working with their attorneys on how to interpret. But what they want to see is good faith efforts for compliance, and they will work with any libraries that need assistance. With respect to collective bargaining, I have this, it's in the statute. But I don't know if small libraries have too many unions. I mean, I don't know that one way or the other, but I guess most of the people that are participating here are not union libraries. But if you are, the effective date is not October 1st. It's when the collective bargaining agreement expires. So if you do have a collective bargaining agreement that covers any of your employees, you'll still have to come into compliance with ESTA along the same lines we have talked about for the last hour. But you don't have to come into compliance till that collective bargaining agreement expires. Same with employment agreements. This is a constitutional issue, basically, but if you have any contracts, and this might be something between the board and the director, probably more so than others, but if there's a contract in place, that contract may change some of the requirements we're talking about. So if you do have an employment contract in place, you want to talk with your attorneys about how that impacts ESTA. So there are now what I have up here is a lot of this is all on the Wage and Hour website on the uh, they've actually been very, very good at providing info. You have I talked about the FAQs, and you see the link here to the FAQs. I have here, you can just pop those on and work around them a little bit. But this is the statute, it's the FAQs, it's the poster. So everything we've been talking about, if you want, you can jump onto the Wage and Hour website. It's a little difficult to get to, but if you go on to their main page, they'll have a box that says ESTA. If you pop into that box,
Mhm.
you'll get right to
Yep.
their ESTA designated page. If you try to get in it any other way, you'll be like me. You'll basically be going round and round and trying to figure out where the heck is all of this. But if you look for that on their main page, and then you look at the little boxes on all the laws in force, there's one that says ESTA. You pop that one open, that's a good place to check around and
Mhm.
find everything we're talking
Mhm.
about.
And I dropped that link in the chat.
Oh, perfect, perfect.
Yeah, it also gives contact. You can get to the contact information so that you can contact the wage and hour people who, yes, are extremely helpful, and have actually offered to come to a director's meeting and chat about this as well.
Yeah, perfect. Yeah, because they've been, I mean, they got hit with it the same way everybody else did. They didn't know exactly what was going to take effect when, and then literally midnight before the law was supposed to be effective, they got
Hmm.
the new law, and
Hmm.
they said, "Oh, and guess what? Now you've got no time, and you got to start enforcing it."
Yep.
So I give them a lot of credit. They've done a wonderful job on getting everybody up to speed and working through this. They've got some great webinars as well. So yeah, that's they can be very, very helpful. So this is the day we've been waiting for quite some time. It's here. Hopefully, what we've talked about today helps. If there's anything you didn't know, hopefully it gets you where you want to go.
Well, thank you, everybody. I appreciate you being here on a Friday, and I hope y'all have a great rest of your weekend. And we will see you soon. Take care.
Okay, bye bye.
Bye. Thank you, Mike.
Yep, thank you.